Hello, welcome to another video from the Center for Connected Health Policy. I'm May Kwong, the Executive Director at CCHP. For today's video, we're going to be looking towards what we can expect in 2023. The day this video is being recorded is December 6th of 2022, so please keep in mind if you are looking at this video at a later date that some of the policies that I'm talking about may have changed. A few disclaimers before we get started. Please note that any information provided in today's talk should not be considered legal advice. It is strictly for informational purposes. CCHP always recommends that you consult with legal counsel if you are interested in a formal legal opinion. And if I happen to mention company or show a picture of a product, know that neither I nor CCHP has any type of financial arrangement, relationship, or affiliation with such a company. So as 2022 winds down and we look to 2023, what a lot of people are asking is, what is the telehealth policy landscape going to look like, especially if the public health emergency on the federal level is declared over? If you have attended any of my talks in the past, you may have seen this slide before. This is an overview of the telehealth changes that were made in response to COVID-19, both on the federal and the state level. As I said earlier, a lot of the changes that were made have been temporary changes, and some of them have expired by this point. Some of them are still around because we are still underneath the federal public health emergency. But if you look at this, you can see that at least certain issues or certain policy areas were very common as far as what was addressed both on the state and the federal level. And then there were other policy issues that were exclusively in the federal domain or in state jurisdiction. So for example, licensure was primarily a state issue for them to deal with, whereas HIPAA is a federal issue. So as I said, depending on who you're talking about, the jurisdiction that you're talking about, some of these temporary waivers have already expired. Some are still around because of the federal public health emergency or a state's decision to keep things around to a certain period of time, or they may also still be either under a state public health emergency or tied their telehealth temporary changes to the federal public health emergency. But the big question is, again, what sticks around? And we're going to talk about sort of what we know will be here in place after the federal public health emergency is declared over, and where things may be going, both as far as what's in federal policymakers' minds and also on what state policymakers are thinking of. So first, we're going to start with the public health emergency. So for those who are not as familiar with the background, it was first declared actually in March, but they backdated to January 31st of 2020. It's been renewed 11 times to this date. The last renewal was October 13th of 2022, which extended the public health emergency to January 11th of 2023. There are all indications that it'll be renewed at least one more time, which would take us out to about April for the expiration date. And the reason for this is that even though there's been no official renewal yet, is because the Biden administration early in the year had said that before we end the public health emergency, we will give states 60-day notice, and that time period has already passed. Also, as been shown by some of the figures we're seeing, people are expecting kind of a pretty tough winter with like not only flu and COVID, so they wanted to keep the options around, some of these temporary options that were put in place for COVID. So we're most likely, though not 100% guaranteed right now, looking at one more renewal, public health emergency, earliest date possibly ending April 2023. What happens afterwards then is a big question. Are we going to get another public health emergency, or is it definitely like over and done with at that point? And if it's over and done with, what we will have, at least on the federal level, is another sort of grace period for some of the telehealth temporary waivers, a 151-day grace period. And I'll get more into that a little bit later. So federal telehealth policy. So post-PHE, there have been sort of three channels in deciding what the landscape for telehealth policy on the federal level is going to look like. So there's your legislative level or legislative channel. That's like a bill passes through Congress, it's signed by the president. Administrative regulatory changes. And these are changes that a overseeing agency will decide that they are going to make as far as, policies affecting telehealth or policies related to telehealth and what it'll be after the public health emergency. For example, CMS oversees the Medicare program, and they've been making some changes. And then guidances and reports that, may not have like the strength of a law or regulation, but it gives you insight into what that administrating or oversight agency is looking at with a particular piece of policy. So we've had something come out over the last, year, 18 months related to all of these sort of channels that give us an idea of what a post-PHE landscape looks like on the federal level for telehealth. So in legislation, we've had two pieces of legislation so far. We have the Consolidated Appropriation Act of 2021 and the Budget Act of 2022. In the one that was passed in 2021, what it did was it did not actually address specific telehealth temporary policies that were enacted for COVID-19. What it did was it created this policy that said for the Medicare program, mental and behavioral health services can now be treated via telehealth without the geographic limitation applying, and the home can be an eligible originating site. So permanent Medicare policy for telehealth says that the patient needs to basically be in a specific type of site and a specific geographical area. And there are certain exceptions, and some of the exceptions are that certain services can take place in the home. But what this new policy says, like, we're going to broaden that. We're going to allow the mental and behavioral health services that we cover to not have that geographic limitation apply. And we're going to also allow the home to be eligible for where the patient's located to receive those services. And we're going to pay for those. However, what this bill did was it put a caveat on that. So while there was an expansion of services, it says like, but for that to happen, for you to avoid that geographic limitation and for the home to be eligible originating site, you need to have had a 6-month in-person visit prior to the delivery of telehealth, prior to the delivery of telehealth services between the telehealth provider and the patient. So that really kind of narrows things down because they're requiring now that the patient and the provider had met in person, and CMS like later clarified regulations said like that in-person visit needed to have had some service take place that Medicare paid for or would have paid for if the patient had been Medicare eligible. So it's not even if like they met in person for coffee and like said like, well, we met in person, so it's fine. It had to have been for a service that Medicare paid for or would have paid for if the patient was not eligible for Medicare at the time. So that is the only way to avoid that geographic limitation and to have the home be an eligible originating site, unless you fall into one of those narrow exceptions that existed prior to this policy being passed and accepted. The other legislative change that has happened during the last year or so was the Budget Act of 2022. So what it did was it's going to delay basically the expiration of some of the temporary telehealth policies that were in place for COVID-19. So it creates what I call a grace period of 151 days after the PHE. Some of those temporary telehealth policies will remain. Now, I said some, so be in mind, it's not going to be all of them. What the ones that are going to remain is going to include like allowing some of the telehealth providers to continue to be eligible to provide services via telehealth and reimbursed by Medicare, such as FQHCs, RHCs, PTs, and OTs. It's not all of them. Right now, underneath the public health emergency, Medicare has said like all eligible Medicare providers can provide services via telehealth that are on the special telehealth list, but it does not. It allows all eligible Medicare enrolled providers. Here with the grace period, it's only going to be some of them. So that's like a difference there as well. The geographic limitation continues to be waived and allowing the home to be on eligible originating site and also allowing audio only to continue to be used. What's also missing from the list are some of the other policies, such as HIPAA. So at the beginning of the pandemic, the Office of Civil Rights, which oversees HIPAA, said, we're going to exercise discretion on whether we're going to like go after you for a HIPAA violation, because we know some people need to use like certain platforms, and some of those platforms at the beginning of the pandemic may not have been HIPAA compliant. So they weren't going to ding you for that because there was this rush to stand up telehealth programs. Well, that guidance is actually not going to be around anymore, or that guidance of like they're exercising discretion, that kind of like, out for you, it's not going to be around anymore during this 151-day grace period. So that's something that disappears. So what we have during the 151-day grace period is not all of the total telehealth policy waivers that we saw during the PHE. It's only going to be some of them, but some of the major ones will stick around at least for 151 days. As it stands now, once we hit 152 days after the public health emergency is declared over, everything goes away. Then we go back to permanent telehealth policies, which is far more narrow than definitely what we saw during pandemic, and definitely what we would be seeing during the grace period as the policies stand right now. Physician fee schedule. So the other way for telehealth policy to be impacted is through regulations, and that's usually the administrating agency or oversight agency will propose regulations and then finalize them and make them permanent. So the big one is through the Medicare program, and that's overseen by CMS, Center for Medicare and Medicaid Services. So they typically every year come out with a set of proposals for the Medicare program of like, what are some of the policies going to be for the following year? And they do that a lot with telehealth. Even before the pandemic, that was like a regular occurrence. During the last 2 years, they have made changes so you get an idea of like what the permanent policy is going to look like after the pandemic. And they did that over the last couple of years that we've been underneath the COVID-19 public health emergency. So some of the changes that they made is that they created a temporary category for those eligible telehealth services. So the way Medicare runs is that they have certain services that they will reimburse if telehealth is used to provide those services. There is a permanent list that these services you can use telehealth to like provide them, whether we're in a public health emergency or not. So that's the permanent telehealth list. There was a temporary list created in response to COVID-19, and that includes like the permanent list, but then there were also a bunch of codes that CMS said, like, for the pandemic, we'll allow these codes as well, too. So over the last 3 years or 2.5 years of the pandemic, what CMS has done is it's approved some of those temporary codes and put them on the permanent list, not a lot of them, but a couple of them. But it's also created another category, another holding bucket, where they said, there are some of these codes that are on the temporary list that we think could be good to put on the permanent list, but we don't have enough data and information on that yet. So we're going to like create a temporary holding bucket for them. And these codes will stick around until the end of 2023 to be eligible to be provided via telehealth, and we'll reimburse for it so we can gather that data. So it's called a category 3 list. So there's like about, I think like maybe 80 of these temporary telehealth codes that we know will stick around at least until the end of 2023 and be eligible to be covered by Medicare. However, unless they get shifted onto the permanent list once 2023 is over, or unless CMS changes the expiration date again, once 2023 is over, they then are not going to be eligible for coverage by Medicare if you use telehealth to provide them. One also thing is that during the grace period, the 151-day grace period, the full temporary telehealth list will also be something that still stays around as well too during that 151-day grace period. But once it hits 152 days, that temporary list goes away. So unless the service was on the permanent telehealth list or in this category 3 bucket, it goes away 152 days after the public health emergency is declared over. What they have also done as far as permanent policy is that CMS is now going to cover audio only being used to deliver mental behavioral health services if certain conditions are met. And one of the conditions, again, is like having that 6-month in-person visit. So they expanded like the modality that could be used to provide services, but only for mental behavioral health services and if certain conditions are met as well too. What they have also done is they've redefined what a mental health visit means for federally qualified health centers and rural health clinics. So for those of you who are not familiar with this, underneath permanent Medicare telehealth policy, no public health emergency is involved. Underneath the permanent policies, FQHCs and RHCs do not qualify as distance site providers. There's a specific list of eligible providers in federal law, and FQHCs and RHCs are not on that list. And that would require a congressional bill and president signing it after it passes Congress in order to make that change. It's not something CMS can do on their own because it's in federal law. So you're asking like, well, you know, how are now FQHCs able to use live video and audio only then to provide services? And how did CMS do that? What CMS did was they redefined what a term meant for these entities. There are specific definitions for what a medical visit and mental health visit means for FQHCs and RHCs. And all CMS did was they just tweaked the definition for mental health visit to include, well, it also includes providing services via live video and audio only, or they call it telecommunication services. So interactive telecommunication services, I think is the exact term. So by redefining that term, they're allowed to use these modalities to provide services, but they're not regarded as providing telehealth, and they're not regarded as telehealth providers. It's just a redefinition of the term. They have to follow all the other rules and regulations around what it means for them to provide a mental health visit, but now they're allowed to use live video and audio only. Because it's a redefinition of that visit, and that's not regarded as FQHCs and RHCs providing telehealth or being telehealth providers, that also means that they do not face those restrictions for telehealth that are in federal law. So the whole needing to be in a rural area type of limitation would not apply here because they're not providing telehealth. They're just providing a mental health visit. It can be very confusing, but it is a little bit of an expansion there for FQHCs and RHCs. And then I said earlier that during the grace period, the full COVID-19 temporary eligible telehealth services list will still also apply or still be active during the 151-day grace period. Now, this is what it looks like what pre-COVID, during COVID-19 looks like, and then post-COVID, just sort of like the overview of like some of the policy changes. One thing that is also going to disappear, so down underneath the public health emergency, telehealth providers have the ability to prescribe a controlled substance without having an in-person exam with the patient or falling into one of the eligible narrow restrictions or exceptions before. That goes away once the public health emergency is declared over. And this was something that was in federal law. This exception was in federal law post-COVID-19. So it's not something lawmakers did in response to COVID-19. It was just something that kicked in automatically because the public health emergency was declared. And right now there's been no change to it. So once the public health emergency is declared over, that option disappears. And if you are a telehealth provider trying to prescribe a controlled substance without having an in-person visit or examination with that patient, you need to fall into one of the other narrow exceptions, which basically means that the patient, for the most part, the other narrow exceptions include the patient being located in a specific type of site, such as a DA registered facility, the type of thing. So again, that's going to be something that disappears and does not stick around for the 150-day grace period, because this was a policy that was in federal law that predates COVID-19. This is more of a specific sort of Medicare overview of what it looks like post COVID-19 of the specific issue areas such as patient location, and then what the permanent Medicare policy is, and then the exceptions that are allowed. I talked about earlier the mental health exception to the rule limitation if certain conditions were met. I also mentioned that there were certain very narrow exceptions that already existed, allowing the home to be an eligible site or not having the geographic limitation apply. Those were, treatment of substance use disorder with a co-occurring mental health disorder. So that was already something that was already an exception before the changes that were made with the Consolidated Appropriations Act of 2021. Other exceptions are also treatment of end-stage renal disease in the home without the geographic limitation as well, too. I talked about guidances and reports. So these are not something that holds the weight of like a law or a regulation, but these are things that will give you an idea of sort of what the oversight agency is maybe thinking of or their approaches to things. So a couple of guidances were issued out, particularly from the Office of Civil Rights that oversees like HIPAA, guidance on HIPAA rules, on what you're doing with audio only, and then on discriminatory practices when you're using telehealth as well too. So these are things I encourage folks to take a look at because it gives you insight on like how they may administer or how they may, what they may be looking at if they are going to investigate anybody or find anybody. And then I mentioned also earlier that the OCR said that the HIPAA exception that they did for COVID-19 or the discretion that they were going to allow was not going to apply once the PHE is declared over. And that's like the specific link to that item. State telehealth policy. So states have been in a different sort of place than like the federal government. Some states have already like settled what their post-COVID-19 policies are going to look like. Some of them have delayed it out and some are still in the process of like finalizing this. What we do know now is live video. Even before the pandemic, every Medicaid program, fee for service program was doing something around live video. But the changes that we have seen, like there have been increases both for store forward and for remote patient monitoring. The big one is audio only. So prior to the pandemic, audio only would not have even been a category that would have been on here because for the most part, everyone thought audio only does not fall underneath the umbrella of telehealth. And there was actually specific policy that says not audio only and fax and email. But because of the pandemic and the recognition that everybody has access to live video, audio only may have been the only way some patients were able to receive health services. So then that's now been incorporated in a lot of telehealth policies as well. And as you can see, more than half the states reimburse for some type of audio only delivered services in their Medicaid program. Private payer, commercial payer laws, again, a lot of them actually existed before the pandemic. What we're seeing now are like tweaks to some of those laws. For example, one of them is like adding the definition or adding to the definition of telehealth audio only. So things like that. Another big area is we're seeing more states insist on payment parity. So prior to the pandemic, only a handful of states had explicit payment parity language in their state laws. We're seeing a lot more states incorporate that into state law. This is like an overview slide of like where we are. So compared to 2022, the Medicaid fee for service and like, what they were doing compared to 2020, as you can see, like there's been increases in all the modalities except for live video since that was everybody was already reimbursing for something. And then the introduction of like the audio only and the private payer law. So this just gives you a sort of like comparison snapshot of what pre-pandemic it looked like compared to like right now 2 years or more into the pandemic. And then as far as like what the issue areas, at least in this past legislative year, what were sort of like the high issue areas of enacted bills, licensing was the big sort of majority winner here of like there were more licensing related bills passed and enacted than some of the other topics that we were tracking. So 41 states and DC passed legislation related to telehealth. 180 bills that we were tracking passed. So that's compared to like about 201 in last year. And then like in 2020, there was only like 104. So that gives you an idea of the rate of like state telehealth policy development, at least as far as like what was going through legislation. So if we're looking forward for 2023, at least for telehealth legislation, what do we have to look forward to? So licensure, I think, will continue to be a big issue as well. Also coverage reimbursement, always something that they're tinkering around, like, but they're going to be very specific. So this year we saw more specificity in legislation on certain issues, not broad sweeping policies such as, all private payers are required to cover services as delivered via telehealth. It was like very specific things such as, these commercial payer laws, they need to apply to PTs and OTs or something like that. Very specific type of changes to like the broader policies. Studies and pilots, always popular. We'll probably see more of those. And then there weren't a lot of pieces related of legislation related specifically to abortion and telehealth that may also pick up in 2023 though. What do we expect? Okay, so I talked to you about like possible one more extension to public health emergency. It is possible it could be extended like one more time after that, but people I think are thinking more commonly it's just going to be one more extension. We know we have the 151-day grace period. We know that is definitely something that would occur. But right now, there has been talk in Congress of possibly putting something into a larger piece of legislation, such as the budget bill, and extending some of the temporary telehealth waivers, perhaps for another year. So that is something that could happen as well, too. There's been no specific language that's been made public. It's only just rumors and talk right now, but something to keep your eye on. The other thing is the DEA telehealth registry. So what I talked about earlier, as far as like the exceptions in the Controlled Substance Act regarding telehealth, and how when the public health emergency that is over, that exception goes away, but there are also other narrow exceptions. One of the other exceptions is the creation of a telehealth registry, which presumably how that would work is if a provider gets on that registry, they're considered a good actor, they don't need to fall into any of the other exceptions. The problem is that registry has not been created yet. So the DEA was instructed by Congress at the end of 2019 to like finalize regulations around that. They haven't even sent out draft regulations. And I know Senator Mark Warner has actually asked them during COVID saying like, where's the registry? I don't know. It's been a couple of years. I don't know if they're going to like do it in 2023. They may get the push because of ending of the public health emergency to like finally do something. So that is something to potentially keep your eye out on. And then there's going to be probably a lot more scrutiny around Medicare claims because of concerns from policymakers around fraud and abuse. And I think you'll see that also on the state level as well, too, with Medicaid claims, of like more examination by policymakers and like, we expand these policies, but is it making it ripe for like abuse and fraud here as well? On the states, there's going to be like continued work on like what is going to be the permanent policies in a post PHE landscape, just because not all of the states have like settled on what exactly they're doing. Licensure, I think, is going to continue to be a big issue, and licensure may be of joining a compact, licensure compact, or maybe not like full reciprocity with state, but again, some of those specific exceptions. We started seeing that this year in that specific exceptions were made to licensure, such as, oh, somebody comes to the state, but they already have an established relationship with the provider in another state and they're just in our state temporarily. Yeah, that provider can like go ahead and like treat you for a short period of time. So certain exceptions like that. There's also been increased concern over patient choice. So, concerns that health plans may force or steer patients into telehealth only, or only like allow like a third party to like provide all their telehealth services and not be able to like have their regular provider, their primary care provider maybe use telehealth to provide services. So we may see like sort of more protections around patient choice coming from the states as well. And then one that's kind of an oldie but still being discussed because nobody seems to like have the magic solution on how to approach this is network adequacy and telehealth. Again, a little bit related to like the patient choice issue as well too, because we're talking about commercial plans and health plans, and also like how telehealth is used, but how would it be used to meet network adequacy standards or requirements? So that is it. That is our end of the year sort of roundup and what to look forward to in 2023. The only thing that I know for sure is that there's probably going to be changes in 2023, but this is sort of like with the information that we have now as of December 6th, 2022, kind of our best sort of forecast and guess on what we have to look forward to. If you are interested in more specific information around states or on the federal level, please go to the CCHP website. We also do have a newsletter that we send out on a weekly basis on updates around breaking telehealth policies or changes and other news and research as well. So I encourage you to sign up for our newsletter if you are interested. And other than that, I will thank you, wish you a happy new year. Again, this is being recorded on December 6th of 2022. And as we have seen over the last 2 years, telehealth policy can change very rapidly. So if you're looking at this at a later date, please check out CCHP's website for more up-to-date information, just in case any policy change has happened. So I thank you. I wish you a happy new year, and we'll see you in 2023.